The long-awaited decision by Judge Wilkin in the district court in California came out last March and concluded that while the rules limiting the compensation to costs of attendance were unduly restrictive, but opening up the door too much can have deleterious effects. So ultimately, college sports as a distinctive product should keep some kind of scholarship system. But it should be based on something called full cost of attendance. That's what is said. When you read through the decision, as you read it, and when you begin to read it, it looks like it's going to be a real win for the plaintiffs. The court is troubled by the anti-competitive aspects of the NCAA system. They're talking about concerted activity, Section 1 violation, at least a prima facie case for that, Section 1 of the Sherman Antitrust Act, which talks about combinations or conspiracies in restraint of trade by two or more. It seems to say, you know what, this seems to be the case. But the court did come up, as it went on, it said, and in its analysis, what the court did, it engaged in what's called a rule of reason analysis, which is what you find in these antitrust cases. That, yes, there is a case that the rules are anti-competitive, but if the other side, the defendant, can say there's certain pro-competitive benefits of these restrictions, and they're not overly restrictive, the courts will say, you know what, they can stand. And that's usually what you look at in these kind of Section 1 cases involving sports, because the sports structure, whether it's college or even professional, has certain anti-competitive aspects to it. And the court engages in a balancing test. And that's what makes the cases really, really difficult. They have to balance what are the good things about the restrictions as opposed to what are the potentially illegal things about the restrictions. And ultimately, the court eased certain rules on educational benefits to liberalize what could be compensated for student athletes. But they did not, the panel did not say, you know what, let's open the door, let's allow them to be paid. That did not happen. And because of that, both sides have appealed this ruling to the Ninth Circuit. And that's where it is now. I don't believe the briefs are due yet, and arguments certainly have not had occurred. So we're going to see what happens in the Ninth Circuit. And I suspect at best we'd have to wait till the end of this year for a ruling, but it could very well be in 2021. So that, again, will be a very significant ruling in this case, and we'll see what happens.